just need to go in that direction right in front of the flight zone.
Okay. Welcome, honorees and guests. Welcome to today's very special lunch event. I'm Sunitha Anjilvel, and I'm the acting president of the Washington State Bar Association. We are all honored to be here today in the presence of our 50-year members. This is by far the largest attendance ever of the 50-year member tribute lunch. Take a look around. What an amount of legal firepower in this room. Big round of applause for yourselves. I'm so happy to be hosting this event with State Bar Executive Director Tara Nevitt. Tara, could you stand and wave so the audience knows who you are? Thank you. Each of you has been a member of the bar for 50 years. Half a century of service. That's quite an accomplishment, and I'm sure you are all justifiably proud. The bar has a rich history, and you are all part of that history. Looking back, we have to appreciate the founders of our great state bar and their vision for our profession in Washington. With 35 original members in 1890, we can all form mental pictures of what the practice of law was like in those early days of statehood. I imagine you can share colorful stories about how your practice has evolved over many years and your experiences in addressing the remarkable and critical need for legal services in our state. While I myself have only been practicing for 34 years, the one thing we all know is that change is constant in our society and in our profession. But one thing that I believe hasn't changed is our commitment to maintaining a noble profession, one founded on serving the public, and a profession we can remain proud of for many years to come. Today, our only wish is that you enjoy this day. Take pride in your accomplishments and take pride in your 50 years of service and membership in the Washington State Bar Association. This is your time to reconnect with friends and colleagues, to share stories, reflect on history, and simply to just have a good time. I'm sure there are those here today who may not have seen their classmates since law school. This year, we are honoring 85 members who have each solidified 50 years of membership with the bar. Collectively, you represent 4,250 years of service to the public and the profession. And that's just the 50-year members in our room. This is an incredible record of service to so many of residents of Washington State and beyond. On behalf of the State Bar, we thank you for your service to our profession and your commitment and dedication over the years. I am also pleased and honored today to welcome Washington Supreme Court Chief Justice Stephen González, who is with us this afternoon. He will be addressing you momentarily. We also have members of the State Bar's Board of Governors. Please stand or wave as you are able. At-large Governor Brent Williams-Ruth. At-large Government Jordan Couch. District 2 Governor Kari Petrasek. District 7 North Governor Matthew Dresden. And last but certainly not least of the governors, our own District 9 Governor Kevin Fay. In addition, we have members of our executive leadership team here, including Chief Disciplinary Counsel Doug Ende, Chief Communications Officer Sarah Nagowski, and, as you saw earlier, Executive Director Tara Nevitt. As well, we have our amazing bar event staff who has worked very hard to put this event together. It's now my pleasure and honor to introduce Washington Supreme Court's Chief Justice, the Honorable Stephen C. González. We are delighted that he has joined us here today to speak to you. Chief Justice González was sworn in as the Supreme Court's 58th Chief Justice on January 11th, 2021, following a vote of his peers for a 4-year term. Before joining the Supreme Court, the Chief served for 10 years as a trial judge on the King County Superior Court, where he heard criminal, civil, juvenile, and family law cases. Prior to his election to the King County Superior Court, Chief Justice González practiced both criminal and civil law. He was an assistant U.S. attorney in the Western District of Washington, a domestic violence prosecutor for the city of Seattle, and he was in private practice at a Seattle law firm. The Chief has received numerous awards throughout his career, including the Golden Scarf from the Seattle Sounders and the 2022 Spirit of Excellence Award from the American Bar Association's Commission on Racial and Ethnic Diversity in the Profession. Chief Justice González earned his BA with honors in East Asian Studies from Pitzer College and his JD from UC Berkeley School of Law, where he was the technical editor of the La Raza Law Journal. He speaks Japanese, Spanish, and some Mandarin Chinese. Chief, we are so honored you have joined us today to help pay tribute to our 50-year members.
Thank you for that introduction. I'm really pleased to be here. Every year that I come to this event, the participants look younger to me. But also there are more women each year that we have this event, and more people of color, as the people in law school and those admitted to the bar have changed year to year. It's wonderful for me to see so many friends. I was pleased to see my friend Ralph Thompson here, who came here from Yakima. He and I played racquetball recently on my trip to Yakima, and his serve is wicked, so watch out if he ever invites you to play. I became a member of the Supreme Court almost 13 years ago, and I joined the court when my predecessor, Justice Alexander, retired. And he retired because our state constitution makes it mandatory that you leave at the end of the year in which you turn 75. And he didn't want to leave. In fact, he was upset about it and told me that he thought about a lawsuit, except that it's hard to argue it's unconstitutional when it says it right in the Constitution. One thing that gives me some solace, that if I reach 75 and I'm forced to retire, at least I'll be able to run for president still, if I want to. So I've been married now with my wife for 30 years. We have 2 sons. They're both at the University of Washington. We're very proud of them. Our older son is majoring in history, and when he called me to tell me that, I told him that there's no future in that. Right? Some are paying attention. But I do keep a picture of both of our sons in my wallet to remind me why there's no money in there. I promised I would tell a couple of dad jokes and then stop. I could go on for quite some time. I'll just tell one more. You know, I'm thinking about starting a diet, except that I have way too much on my plate right now. Yeah. So let me talk a little bit about what the Supreme Court is doing. We issued a letter on June 4th of 2020 calling the legal profession to step up and do something about the legacy that we've inherited of the devaluation of black lives, the disproportionality of people of color in the justice system, and the injustice that we as a court, through some of our opinions and likewise, have been a part of and acknowledge our responsibility for. That letter was signed by all 9 of the justices on the court at the time, and we've worked to try to live up to that so that it's not just rhetoric, but indeed an effort to change the way the justice system is administered and make it more fair, more equitable, and more just. So I wanted to talk a bit about what we've done in that effort. And we are now publishing a document that tries to list in 3 categories the work of the court. That is our work through rules, which is the legislative function within the judicial branch, through cases, which is the traditional common law issued by the court, and through the executive function of convening the discussion and having research done through our boards and our commissions. And among the things that we have done include revising GR 26, which requires now judicial officers to receive regular diversity, equity, and inclusion training. We revised General Rule 31 to limit the access to juvenile records for those who no longer commit additional crimes after reaching adulthood. We adopted General Rule 37, which has become a model for many other states throughout the nation and the first of its kind in the country, which changes the way that jury selection operates, recognizing that Batson failed to achieve its target of reducing the elimination of prospective jurors for discriminatory reasons, masked by facially neutral explanations. That rule imported a concept of a neutral observer, an objective observer, and we defined that as someone who is aware of the history of implicit bias in the justice system. It has resulted in a number of things. One, as I said before, other states modeling their new rules after ours. 2, additional training, thought, and discussion about race and jury selection. And finally, more diverse juries than we used to have before the implementation of the rule. We enacted General Rule 38, which prohibits the civil arrest in courthouses for those who have a civil arrest warrant from immigration and naturalization. I believe it is not a political, but an access to justice and a fairness doctrine to say that our courts need to be places where anyone feels free to come to resolve their disputes without fear of that sort of enforcement, so that if you're a witness, you can come. If you have a claim, you can come. If you're a defendant, you can come to the courthouse. If your children are in juvenile detention, you can come and support them without fear of enforcement of federal immigration laws. This is something that became obvious to me when I was a domestic violence prosecutor for the city of Seattle, doing the elder abuse and the child abuse cases, and the difficulty we had convincing victims first to call 911 and then to participate to get protection orders for fear that we were the same as immigration enforcement. We adopted rules making it easier to complete your legal financial obligations. We allow defendants to appear through counsel more often, which reduces the number of times you need to take time off work, pay for parking, etc. We amended RPC 4.4 to make it clear that it's a violation of the rules of professional conduct to use someone's immigration status as leverage against them in a civil lawsuit. We adopted amendments to RPC 8.4 to prohibit discrimination on the basis of gender identity and gender expression. We've adopted stipends for our externs at the Supreme Court, recognizing that we were finding it hard for people of modest means to take the time off to travel to Olympia to extern at the Supreme Court. So we've expanded those who are able to take advantage of that learning opportunity to extern with us. Through cases, we have said that you have to have an individualized hearing before you can bring someone shackled into the courtroom for their appearance with a specific finding of necessity rather than the blanket rule that some jurisdictions were using. We held that there's a heightened requirement under the Indian Child Welfare Act at all stages of dependency and termination proceedings when there's any hint that a child may have tribal connections. We overturned, in an opinion I penned, the Price versus Evergreen Cemetery case, in which the Supreme Court said that it was okay to prohibit the burial of a black child next to a white child in a graveyard. And we addressed some of the language in that opinion. It wasn't just the incorrect legal holding, but the disparaging language that was used towards our black community that we've since disavowed. There have been a number of other cases. I'll stop giving those details and just say that it's been an honor to work now on what is the most diverse Supreme Court in the United States. Now, perhaps Puerto Rico and Guam have us beaten, but among the 50 states, we are the most diverse Supreme Court in the United States. And it's made a real difference. It's made a difference not just in the appearance, but I think in the substance of the conversations we have. All of the studies that were done on juries found that a heterogeneous group is better on every objective measure than a homogeneous one. Specifically, the studies found that a mixed jury is more likely to actually follow the directions from the court. They're more likely to actually review the exhibits that have been admitted in evidence and given to them in the jury room. And they're much more likely to actually talk to each other and discuss the issues before reaching a verdict. There's one measure on which they're not better, and that's efficiency, because actually doing that takes a little more time. I think that expense is worth paying. I think that same idea has worked with the 9 of us when we meet together and discuss issues and decide cases. There's a richness to the discussion that wasn't there when I first joined the court as the only person of color on the court 13 years ago. And I'm hopeful that we'll continue with the recognition of that importance and embrace that as we recruit people into the profession. We have found that the way we have administered the bar might not be the right way to do it. During the pandemic, we authorized diploma privilege, that is admission to the bar for those who successfully completed our state law schools, because we kept planning the bar and then having to cancel it due to pandemic concerns, and people would study for the bar and then not be able to take it. And that experiment has been instructional, because so far, those folks who joined the bar that way have not had a higher rate of complaints, misconduct, or any other problems. We formed a task force to study the admission to the bar and recommend to us ways that we might change that admission criteria. We adopted their recommendations and have sent those recommendations back for study and implementation to the bar. If you're curious and interested in that work, please contact the Bar Association. I'm sure they'd welcome your input as we try to build 2 different ways to become a member of the bar aside from the bar exam, which incidentally has also been updated and will be administering the next gen bar exam starting in July of 2026. But the other 2 will require study and a demonstration of your ability to practice before admission to the bar, and those rules and the criteria are being developed now. But another problem that we're facing is a severe lack of people who are serving as public defenders, especially in certain rural parts of our state. And I think it's a problem with, in part, the way that we even recruit students in the first place. We're much less likely to take somebody who grew up in Seattle or another big city and have them live in a rural community and be a public defender. I think there are plenty of people in those rural communities we should be recruiting in the first place, as they're much more likely to go back and practice there and be a part of the community from whence they came. But we need to make sure that law school is actually an affordable place to study. It costs way too much. We treat it as a professional school, and although it is in some ways, it's also a significant way for us to maintain our civics and service to the rule of law in this nation. And if we expect people to graduate and do that public service as civil legal aid attorneys, as prosecutors, as public defenders, they can't come out with $250,000 worth of debt and make that a workable solution for them. It's something we must change, and we must change that together. I'm hopeful that the years of wisdom and experience you have, you're going to lend to these additional pathways, that you'll help us recruit from rural communities, and that you'll actually step in and help us train these new law students and those studying to become the professionals that we need to service our entire state. I want to thank you for letting me take a few minutes of your time. I'm not going to use the full 25 minutes they allotted to me, but I want to say thank you very much for the service you've given to the state of Washington. It's a privilege to stand here before you. Thank you very much, and congratulations.
First of all, I want to give a formal apology to the chief because I spilled water as I was walking away. I knew this wasn't going to go completely smoothly. We're going to take a little break, and hopefully you will have time to continue to enjoy your lunch, your conversations, and your collegiality. And then I will be back up in a few minutes to continue paying tribute to you. Thank you. Hi, everyone. Love seeing so many people engaged in conversation, and that's what part of this luncheon is all about. But I'm going to take you down a little stroll of memory lane to the year of 1974. Sunday, Monday, happy days. No, I'm not going to sing it. I'm going to spare you my voice. It's terrible. But 74 was the year the popular sitcom Happy Days made its debut, and it quickly became an essential part of American pop culture. 1974, Barbra Streisand had her first #1 hit with her iconic song. Any guesses? The Way We Were. And the top song of the summer, Band on the Run by Sir Paul McCartney. He was not a sir then, and his band Wings. The 1974 movie, which won the 46th Academy Awards, sweeping the Oscars with 7 awards, one of my favorite movies, The Sting. On the other side of the world, on March 29th, 1974, the Terracotta Army was discovered. Chinese farmers near Xi'an stumbled upon a hidden chamber containing 6,000 life-size terracotta warriors. One of the most memorable news items of 1974 was when President Richard Nixon made history when he announced his resignation from office following the revelation of his involvement in Watergate. And for lucky number Super Bowl VII, the Miami Dolphins won their second consecutive Super Bowl win and third year in a row playing in the game. All of that happened in 1974. But in all seriousness, what also happened that was so significant for this great state was that a number of bar members were admitted who have now gone on to serve the bench, and others who are elected officials. Surrounding you are former State Bar Board governors, as well as former staff, including the head of the bar's legal department. Still more of you were bar volunteers, including a fair number of disciplinary hearing officers. We also have a handful of prosecuting attorneys and public defenders. And let's not forget our renowned legal professors in the room. I'm in awe of the class of 1974. You are a very service-oriented group, and the fact of your showing up to this luncheon is just an amazing testament to your involvement with the bar, and we are so excited to recognize you. I'd like to now ask members of the Board of Governors to join me at the front of the room, where we'll be handing out your certificates and pins. It is our great pleasure to present each of our 50-year members with a commemorative certificate and pin. When I call your name, could you please either stand or raise your hand? You can stay right where you are, and we'll have one of our board members or executive team walk over and present you with your pin and certificate. So I'm going to start reading the names right now. From the class of 1974, Michael Andrews. Sharon Armstrong. Richard Bangert. Robert E. Beatty III. John Bell. Lorna Bigsby. Robert Baruchowitz. George Bowden. Kurt Bulmer. Not here. Donald Carter. David Condon. Tom Conum. Rebecca Craig. Kenneth Davidson. Peter Day. Dennis DeFelice. William Drew. David Duskin. Richard Ekman. Donald English. No? Okay. Robert Erickson. James Feldman. John Ferguson. I'm going to repeat: John Ferguson. Royce Ferguson. Kelby Fletcher. Jay Fortune. Martin Fox. David Freese. Peter Galbraith. Theodore Gath. Andrew Gowan. Robert Giles. Jeffrey Goltz. Helen Harvey. Calvin Jackson. Stephen Jones. Michael Johnson. Tom Keefe. Tom Keefe. Thomas Kelly. Carlton Knapp. Francis Ladenburg. John Ladenburg. Patrick Lehman. Robin Lindley. John Ludwig. Joseph Mano. Joseph Mano. Ken Marble. Marcia Mellinger. Anthony Menke. Dean Messmer. John Meyer. John Monahan. Christina Mrak. James Neat. John Panesco. Richard Perednia. Lou Peterson. Drew Pettis. Thomas Platt. Richard Prentke. Anne Redman. Michael Reinhardt. Michael Reynolds. John Ryherd. Morris Rosenberg. Jerome Rubin. Nicholas Scarpelli. Robert Schmidt. James Sedney. Okay. William Severson. Craig Smith. Lee Smith. Richard Smith. Yeah, Richard Smith. I'm sorry, great, thank you. Nancy Sorensen. Hugh Spitzer. Michael Tardif. Evan Thomas. Ralph Thompson. David Thorne. Josephine Vestal. Linda Wandell. Paul Wasson. Judge Kenneth Williams. Thomas Williams. Don Wittenberger. Gary Wolfstone. George Yiannakis. So, is there anyone from the class of 1974 whom I may have missed? If so, please identify yourself. Also, I apologize if I've mispronounced anyone's name. We tried. Please join me in congratulating our 50-year members. Great job. I want to thank all of you here today, those we honored and those who came to honor each of you. It's been a true pleasure and a reminder to me of why we should be proud to be a lawyer in Washington State. I congratulate and commend our 50-year members for the difference you've made in our profession and your contributions in shaping the bar's history and its future. If you would like to be part of a group photo, Jennifer will show you where and how we'll do that right after I'm done speaking, which I promise you is very soon. Because there are 85 50-year members, we're not able to fit everyone in one photo. So if you can listen for Jennifer's instructions, we will have 3 or 4 group photos alphabetized by last name. This is the end of our luncheon. Please feel free to stay as long as you'd like. You're also welcome to enjoy the museum's exhibits until they close at 5 o'clock. Please see Jennifer for a wristband, if that is what you want to do. And thank you again for such a memorable day.
Donald